All right, perfect. Well, I think we can get started here today. So again, hi everybody and welcome. Happy holidays. 'Tis the season, right? We got some snow on the ground here, at least over on the west side. We got a little bit, which is gives a little bit of pop of festivity here. But again, just want to thank everybody for joining today. Whether you're from Young ACG, Women in Transactions, ACG, or you're not part of our group and you're joining us today, welcome. This is a fantastic opportunity that we have as a community to connect here in this virtual panel event. And we have an incredible panel with us who are speaking on the basics and importance of estate planning. And we hope that you walk away from this event learning more for yourself personally, and we're hoping that you can take this information and transfer it back to your clients who may be going through an M&A deal right now, and they have some considerations around this that you can help work them through. So again, thank you for being here today. Hopefully you'll walk away with a lot of good information and knowledge about this topic. But before we get started, I want to thank you to our Young ACG and WIT sponsor, CIBC, for making this possible. This has been an odd year, right, in so many ways. So we want to just take that moment to thank you for making this possible. Again, very excited for this panel event today. Before we get started with introductions, my name is Katie Kelly, Senior Manager in Deloitte's M&A Transaction Services Group. Been with ACG for over 6 years. We have Margaret Jordan, who will be my co-moderator, and our panelists, Culp and Cassandra Manna. So thanks, ladies, for being with us here today. And we do have a few housekeeping items before we get started. First, we have a Q&A chat function, and we want you to use that today. You know, want this to be an open discussion, active participation from all of you. This is a great topic. I know I've learned a lot from just talking with Cassandra and Laura over the last month or so about this. And I hope that you will take advantage of this opportunity. And second, we'll have a few polling questions throughout this Q&A session. So we also encourage you to answer those. We have a couple fun ones here. And third, if you attend the entire session, you'll be entered into our door prize raffle at the end of the hour. So encourage you to stay with us. We're going to have, how it'll break up is this first 30 to 40, we're thinking it's going to be closer to 40, 45 minutes on this Q&A session. And then we'll separate everybody out into breakout rooms to network a little bit more, because I know our community likes doing that. And then we'll continue to talk about this topic on hand of estate planning. And again, just get to know one another a little bit more, or reconnect if we're seeing each other for the first time in a while. So before we get going, I'm going to turn over to Margaret for a quick introduction.
Good afternoon, everyone. Thank you for joining us. I'm Margaret Jordan. I'm the Director of Business Development at YACG, which is a public accounting and business advisory firm here in Northeast Ohio with a national presence. I'm also the chair of the Women in Transaction Committee for ACG. It's our pleasure to be here today with YACG and co-host this event. I'm really excited about the content we're going to cover and our speakers. I just wanted to remind you that we do have the chat feature and we're going to be doing some polling questions. So please feel free to speak up at any time and ask a question, and please respond to the polling questions. We're going to start with our first polling question today. What is the definition of estate planning? So you can choose one of these and submit your answer, and then we will see what the correct answer is. All right, we'll give it a couple more seconds for the polling, and then we'll show the results. Right on. Everybody got it right. That's awesome. Good job.
Very good.
All right. Well, thanks for doing that, everybody. So before we get started, I'd like to turn it over to Cassandra Manna and Laura Culp. Cassandra and Laura, would you go ahead and please introduce yourselves and tell the group a little bit about yourself and your practice, and then we'll go ahead and get started on our presentation. Cassandra, you want to go first?
Sure. Hi everyone, my name is Cassandra Manna. I am an attorney at Brennan Manna Diamond Law Firm, and I focus on estate and trust planning. But I come from an M&A space, so I've been involved in M&A deals and understand how that tends to affect long-term planning for your money, your assets through the generations and during incapacitation or after death. So I'm really excited to be here because this topic is really important and just for individual adults in general, but also it's a real value add that you can bring to your clients when discussing their various plans for the future for both their businesses and from a personal standpoint.
Wonderful, thank you. And Laura Culp, would you go ahead and please introduce yourself?
Sure. Good afternoon, everybody. I'm Laura Culp. I'm a tax partner and wealth advisor with YACG. So I work with Margaret, and I have worked with clients on M&A transactions, obviously, from a tax standpoint, trying to save people taxes, and then after they sell their businesses, investing their money. So which is rather fun. Also, I do work with our clients to help them with their estate planning. Obviously, we need people like Cassandra to actually draft the documents, and it is very important to have an estate plan, no matter what your age. As a matter of fact, my daughter, who is 26, got, when she was at med school, they actually provided services to the med students for them to have wills and powers of attorneys and things like that. So even when you're a student, you need those kind of things.
Very good. So before we get started, Cassandra and Laura, were you surprised by the polling results for the first question?
I think we have a pretty intelligent group here, so I wasn't surprised at all.
My thoughts exactly. Cassandra, what do you think?
I'm second everything Laura said.
All right. Cassandra, can you dive deeper past the definition of estate planning and talk about the basics and processes around it and things that our audience should consider going forward?
Yeah, often when people hear about estate planning, they assume that means rich people, millionaires, people with big businesses, and they assume it doesn't apply to them. But an estate plan is something that every adult needs, from an 18-year-old that's just going to college to, a 55-year-old that has multiple companies and, millions of dollars in investments. So it's more than just something that rich people do, for lack of a better term. A basic estate plan includes a will, a healthcare power of attorney, a financial power of attorney, and a living will. And then depending on your situation, we recommend that a trust is created. The number one goal of estate planning is to avoid probate. And what we mean by that is to avoid having the courts involved, the state, the government, et cetera, involved in what happens to all your stuff after you die. If you plan ahead, you can paper what you want to happen with all of your investments, your property, your jewelry, and make sure that the people near and dear to you are cared for and that it goes to the right people. It also helping by papering everything, it helps streamline the process. So typically when someone dies, you leave behind family and friends who are mourning your passing, whether you've lived a long life or, something else. And by streamlining this process, it makes the mourning period for them easier, and it takes away the stress of having to figure out what to do because it's all there put in writing. Additionally, from a business perspective, it's really important to include estate planning, and owners of businesses should really make this a priority. If you are an owner of a business and you have a partner that also owns that part of that business and you die and you don't have an estate plan in place, often a lot of your business information becomes public because the probate courts are involved. Again, the government, it becomes public record. So your partners that remain, the business, that remains becomes public records, and people don't want that stuff out. So by planning, you can prevent situations like that from happening.
So besides contacting you, who should someone contact that if they're planning to start this process? Who do you recommend that they contact?
Yeah, the two most important people to contact are your attorney and your accountant. You know, again, as Laura mentioned earlier, I can do the drafting of the documents, tell you legally, here's what can happen, here's what won't happen. From your business perspective, I can talk to the various owners and say, you know, this is what will occur if this situation happens, and here's how we paper it to prevent, you know, any issues. Having an accountant like Laura come in and talk to you about the tax implications of, you know, if you're selling your business, what's going to happen with, you know, the payout that you receive? How do you invest that? How do you create passive wealth with that money that could last for generations? Between the two of, you know, our careers, our people in our fields, we can really provide a full service, multi-generational plan for individuals.
I would just also add that, you know, the accountant, the CPA, typically, especially if you're doing somebody's tax return, you know a lot about the family, you know a lot about their personal finances because you see it all in the tax return. So I think that helps in a lot of times where I start is just figuring out what is somebody's net worth made up of. You know, what bank accounts they have, what investment accounts they have, what IRA accounts they have, what are the beneficiaries of those different accounts if there are beneficiaries. The business, as Cassandra mentioned, you know, the houses, and really coming up with a net worth statement, and also if there's any debt. So then you can make sure that you're addressing with the client, where do they want those assets to go? And then how we're going to get it there. And then after that, and you have the attorney in the room too, and possibly a financial advisor as well, possibly, especially if we're talking about transferring assets to another generation, like during lifetime. But then I think you can have that conversation about, you know, what do you really want to have happen, and when do you want your children to inherit? For example, when you have young children, you usually don't want them to all of a sudden inherit a great deal of wealth, which is where the trust comes into play, which we can talk a little bit more about. But I think that's a really good place to start, is figuring out, you know, what you have and then where do you want it to go. And then Cassandra or an estate planning attorney can then draft the documents accordingly. The one thing I would say is everybody needs to have a will, and because the will's like it's like you say what you want to have happen when you pass, and that's where you indicate who the guardian would be of your children, for example. And if you have young children, it's really important to have a guardian, and it's a pretty serious decision, because especially if you don't have family, you know, what friends can you trust? And I know, like for us, our children are grown, but originally we had my parents being the guardian, and then my sister-in-law, but you know, everybody was getting older, including our children. So then we went with you know, younger friends. Now we don't need that anymore, but you know, that's what we had to think about as, you know, as we aged and they aged, you know, who is appropriate. And then you have to think about who's going to be your executor. And again, you know, we started with being my dad, and then we've gone to friends again, but now we're going to change it to our daughter probably to be our executor, because she's now old enough. So, you know, how you decide to do things will change over time. So it's not a one-time thing, right, Cassandra?
Yeah, I definitely recommend when I start an estate plan with someone, especially if it's their first time around, you should really reevaluate it every 3 to 5 years, unless there's a huge life change in between that time period. You know, divorce, marriage, children, if you previously didn't have any, those are, you know, big things that will change where you want your stuff to go. If you win the lottery, that's a huge thing that could affect what you do. So it's something to reevaluate every few years for sure.
Right, very good. Now that we understand the basics of what estate planning is, Cassandra and Laura, can you please outline what the benefits are and overall importance of are of estate planning?
I think the first one, which Cassandra already mentioned, is to avoid probate. It's costly. If you don't decide, as she already mentioned, the government will decide. I had a client who died, and even though had a will, had a trust, hadn't titled things correctly. So that's the one piece, it's you can get the documents drafted, but if you don't carry out the entitling assets in the right name, everything you've done really has no value. But anyway, this client had paid a lot of money for estate planning, did not title things properly, and died rather suddenly. And there was a privately held business that information was going to be going through probate, except that the attorney was able to convince the court to keep the information private. And that it would have been very detrimental to that business for their competitors to see how much that business was worth. And of course, that was only one member of the family that owned the business. So it was important to the family. What's been interesting about this is it turned out that other members of the family didn't have things titled correctly either, particularly with some partnerships that they owned. So guess what's happened? Everybody's gone back to their attorneys and gotten everything titled properly. So that was I guess, it's a tragedy that they lost a family member so young, but the good news is that everybody's learned a lesson from what happened to their sibling, and they're not going to repeat that mistake.
Yeah. As Laura said, it is very important because of the public nature that can occur if you don't have an estate plan in place. I had a client that died without an estate plan, and he was one of 3 owners of a business. And unfortunately, the various attorneys involved, we were not able to keep everything private from the courts. So a lot of information, if anyone with any detective skills got onto the county website, could look and see how much the individual who died, his interest in that company was worth. And you can extrapolate from there about what the company's worth. And all of you that have clients that are in this buying and selling market, I mean, if your client's trying to sell their company and, they're getting offers for $10 million, and then they find out that a 1/3 owner's interest is only $1 million, people start speculating, okay, maybe I'm overpaying for this. And it becomes an issue if you try to sell. So that's an important value add that, we like to bring to our business clients, and something that you guys can bring to them as well is, does the corporate governance documents allow for a transfer of an owner's interest to their trust? And if so, is there a trust in place that will, be able to hold the interest and be managed properly? In a way to, again, avoid the probate side of things. So it's really important.
And actually, to add on to what you just said, about the corporate documents, does it also allow transfer to family members, right? Or to a trust for the family member? So, because one thing that a lot of people do, especially if they're looking to sell a business, they might decide to before they sell the business, to transfer a portion of that business to their children, like for a trust for their children. So you have to make sure that the corporate documents will allow that. And it is it's a good way to, transfer a portion of the gain from the sale of the business to maybe to a generation that's in a lower bracket, at the same time, sharing the wealth. So getting that portion of the company out of your estate as well. I should point out that you don't have to use a trust for everything. I mean, there are ways to transfer assets without a will or a trust by naming beneficiaries, for example, on your IRA or your 401k or life insurance. Make sure that you've got the right beneficiaries. Or if you get a divorce, make sure you change the beneficiaries, because that also sometimes happens, is someone gets divorced and they forget to change the beneficiary in their life insurance, and then something happens and their ex-wife or ex-husband all of a sudden has this life insurance policy, and he or she may not be willing to sign it over, just to disclaim it to the person who really should get it. Also, you can have bank accounts or investment accounts payable on death to somebody. So again, there are ways to go about transferring assets without using a trust. But if you have children or you want to control your assets after your death, say it's a second marriage, for example, and so you want to be able to provide for that second spouse, but make sure your assets go to your children, you really need to have a trust to be able to do that.
And that's something when you work with your accountant or your attorney or clients do. I mean, I have a whole questionnaire that I go through with my clients or have them work through on their own with their spouse that asks, do you have this type of asset? Do you own real estate? Do you have bank accounts? Okay, are they checking? Are they savings? Who is the title beneficiary of your 401k? Et cetera, so that you can get those clients thinking of these assets, because as Laura mentioned, some transfer via a will and a trust, but some transfer outside of probate if you designate a beneficiary. But again, the whole point is let's avoid probate, whether it's through designation of a beneficiary or through the terms of the will or the trust as applicable.
All right. To build on this, what may be on the horizon for many of us joining the call today? What considerations should we be thinking about going forward for ourselves and our clients?
I think a big consideration is that we are having a change in administration, and what is going to happen to the state tax limits. I mean, currently we have very high limits where you can leave, pay basically around $12 million to someone other than your spouse and avoid probate tax. So a couple of 24 million. That does sunset in 2025, but it is, I'll be honest, I think regardless of who is president, because of all the debt that our country has already had and then has increased due to COVID, I think there was probably going to be a change in the estate limit anyway. So if you have very wealthy clients, they might want to be thinking about giving away things now and using up that exemption while it's so high. Because, at one point in time, the exemption was $1 million. There's a lot of people who would have to pay estate tax if the exemption went back down to $1 million, right? So talking to people right now about gifting to their family members, again, using trusts, you can still, for example, if you, like I already mentioned, transfer a portion of your business to a trust, you can still control, you can, be the trustee of that trust, or have your spouse be the trustee and still control that trust, not, necessarily lose control, but still give up enough control that it's out of your estate. And a lot of people are thinking about that and who have a lot of wealth and are doing that. As a matter of fact, I have a client who doesn't have an operating business, but has an investment LLC. And I just got the documents where she gifted more of her LLC to her children. She's leaving a certain amount for herself that she thinks she needs to live on, but then she's basically gotten rid of through the LLC, through interest in the LLC to the children, gotten rid of the rest of her assets so that she can give them why the estate exemption is so high.
Another thing to think about, especially in, as members of ACG and you work in the M&A space, when your clients sell their company and they get a huge payout of multi-million dollars or whatever, is talking to them about what they want to do with that money. Obviously invest it somehow to start increasing it into the passive wealth that we've talked about if they don't plan on taking it and, buying a new company or something like that. But also talking to them about what they want to do with that money and what they see that money being used for the next generation or 2 or 3. If they have young kids, are they prepared? Are the kids going to be taken care of the way that they want if something tragic were to happen? If they have older kids, are they educated on how much money your clients might have. A lot of times kids are unaware, even as young adults or, older adults, they have no idea how much their parents have. And then their parents die and they inherit all this money. Like, what are they supposed to do with it? So that's a good conversation to have. Obviously the planning beforehand also includes, okay, is there enough to make it to the second and possibly third generation? And if so, how do you want it to get there and what do you want it to be used for?
You could also, if they're charitable minded, that might be part of the conversation also. Whether they want to use some of their assets for charitable giving during their lifetime. There's some estate planning vehicles we can use that you can get income for life, and then at the end of when you pass, then those assets can go to charity, charitable remainder trust, for example. A lot of times, if I have clients that want to leave assets to charity at death, we talk about using their IRAs. That's a very tax efficient way to give money to charity. First of all, if they're 70 and a half, they can give up to $100,000 a year to charity out of their IRA and not have to treat that as a taxable distribution, and it can be used to offset their required minimum distribution. But then at death, if they leave the IRA to charity, the charity doesn't have to pay any income on the IRA, which if you leave it to a family member, that family member has to take distributions, and those distributions are taxable. So if you were looking at, types of assets to leave to charity at death, an IRA would be preferable, say, to investments, for example. So that can be part of the conversation. And people that sell their businesses for a lot of money sometimes set up private foundations also. I've had that happen a number of times. Or they use donor advised funds to give away part of their wealth.
But from a personal perspective, for each of you individually or your spouse, your siblings, your friends, your parents, everyone needs a will, and everyone should get a healthcare power of attorney, financial power of attorney. Those documents are, if you get in an accident and you're in a coma and you need surgery and, someone needs to make that decision on your behalf. Who do you want making that decision? Usually if you're married, your spouse does, but if you're not married, who do you want to make that decision for you? As Laura mentioned, years ago, she had her parents named, but as they got older, it was like, okay, maybe I should name my siblings or a friend that's more my age. And she's talking about naming her daughter eventually to make those decisions. Who's going to pay your bills when you're in the hospital or you're, again, coma is a perfect example. Having a financial power of attorney allows that person to access your bank accounts to make sure things are paid in time. And it's something that we don't really think about, but if you have kids that are going off to college, you've always been part of their doctor's appointments, sure, but they go to college and they get COVID. The hospital is technically not supposed to tell you anything unless you're named as their healthcare power of attorney. So having your 18-year-old kid sign one of those so that you can still assist them with those healthcare decisions is very important.
Maybe, Cassandra, just to expand on that financial power of attorney, basically it gives that person the right to make any financial decisions on your behalf. So, like she already mentioned, paid bills, set up bank accounts, close bank accounts, basically make any financial decisions on your behalf. It is important, but it's also something that you want to be careful who you give that power to. And I know most attorneys hold on to those power of attorneys, right, until, like in their files, until it's needed, right? So that, like this would never happen, but if I gave it to my son that, he wasn't running around, taking money out of my account without me knowing, right?
Right. Yeah, because those can be viable, as soon as they're signed. There are ways to limit them, but it just gets a little complicated at that point. But, it's good to have one in place. And like Laura said, maybe leave it with your attorney and then let your accountant, like Laura, or your banker know, hey, by the way, name my son as my power of attorney. if he ever shows you the copy of it, he's the person you can talk to if there's something wrong with me. But yeah.
Then the healthcare power of attorney, you should really make sure like your doctor has it, right?
Yeah, I always
The hospital.
Yeah, I always recommend the healthcare power of attorney, give it to your primary physician or any other doctors you regularly see, maybe your local hospital, or in your files somewhere. I know a lot of hospital now have electronic files, which are great to upload that to. Again, typically those come into play when it's like it's an emergency. You're in a car accident and you're unconscious. So like who's making these decisions if they have it on file? It streamlines the process.
Yeah. So Laura, Cassandra, great top of mind topics, right? I think we get caught up in our busy day to day that a lot of these, to your point, you don't think about until the last minute, right? So thanks for bringing a lot of those up, because I mean, even to your point about COVID, Cassandra, like we're just like, that's just something where it's like, oh my gosh, didn't think about that. Right.
Right.
And so all of this is incredibly important. So thank you for giving some more background on those. And I guess it's a great segue as well to our next polling question. And Julia, if you could please bring that up, it's how many of you have a will in place? And now that I'm a mom, my husband and I are like, wow, yeah, we need to think about this, right? It's something that even before, to Cassandra and Laura's point, like, an adult should have these, kids or no kids. And so, oh, great, we have our results. So 60% yes, 40% no. I'll pause there real quick because it's almost 50-50. I mean, Laura, Cassandra, any reaction to that? I mean, does that align with who walks into your office and says, hey, I need to get a will in place, or I need to think about this, or can you help me? Does that shock you, or is that pretty much on par for what you would expect?
Well, I think it's probably indicative, first of all, of the age group that we're talking to today, but also Cassandra may know the percentage, but there's a very high percentage of Americans that do not have wills. So I'm not necessarily surprised. I think that probably the percentage that do have wills is probably higher than the norm, because again, we're dealing with very intelligent group of people. So what I would say to those of you who don't have a will, you need to get one. So don't delay, especially if you have children. Cassandra, do you want to add anything?
No, I second everything you just said. Again, this field that we're in, we hear this lingo a lot. So I am not surprised that there's 60% that have wills, just because we're exposed to it more. But I would say that the average person does not have any of this planning in place. Right.
Yeah, no, that's I agree with it. I wasn't going to be too surprised with your reactions there. And that brings us to our next polling question, because Cassandra and Laura, you have talked quite a bit about the use of a trust throughout our discussion here today. So just want to get a sense from our listeners here, what is a legal trust? And I will say I had some fun coming up with one of the multiple choice questions here. A couple more seconds here. Hoping for 100% correct here with these answers. All right. Very good. I do have a good feeling about the Browns making the playoffs this year. I'll say that. But good. Glad everybody got this one correct, right? So a legal trust, fiduciary arrangement that allows a third party or trustee to hold assets on behalf of a beneficiary or beneficiaries. And since we've talked about trusts, I think we'll And everybody got that correct. I think we'll go on to our last polling question because Cassandra and Laura, this is something else that you've talked about here in our discussion this afternoon about the healthcare power of attorney. So polling the audience here, do you have a healthcare power of attorney? Give it a couple more seconds here. All right, if you haven't had a chance. All right. So 64% yes and 36% no, which pretty much aligns with our how many of you have a will in place. Cassandra, Laura, any reaction to these results here?
No, I mean, I'm assuming that the people that said they have a will also said they have a healthcare power of attorney. If you're working with a lawyer, usually that's like all part of the package is you're doing a will, you're also doing those powers of attorney. So that doesn't surprise me.
You can get, I mean, you could do your own healthcare power of attorney, right, Cassandra? I mean, it's available online, right? The Ohio form.
Yeah, there's a standard form that's used, that's recommended to be used. You can use a non-standard form if you are really specific about certain things. But if you look on, the Ohio Supreme Court website, or AARP is a really good place to find stuff like for that, especially if you are moving to another state or something like that. All the AARP per state websites tend to have that information on there.
Awesome. Well, thank you both. I mean, is there any topic that we haven't hit on yet that you think would be super beneficial for this group here today?
I think maybe just everybody should review their estate plan and make sure that they, at least have a will and, consider a trust. And of course, various power of attorneys that Cassandra already mentioned. It's just a good practice to get into and think about doing every few years.
We did have a question come in through the chat feature. The question says, can you address charitable gift of business interests in context of transactions, specifically transfer restrictions on closely held shares, ROFR, buy, sell, etc. Also, tax treatment of gifts to CRT in advance.
You can do that. You can transfer, assuming that the corporate structure allows that. Typically, you'd have to have, a valuation to know what the value is of the stock that's being transferred. And you're technically not supposed to have a agreement to sell that stock before you transfer it to the charity. So there are quite a few hoops that you have to go through, but you can't. But it is possible to give stock to charity or to a CRT in advance of a sale, and then have that, have the buyer buy those shares from the CRT.
And that's where, again, what we keep talking about is planning way ahead of time before everything becomes an emergency. So, as Laura said, there's a bunch of boxes you have to check for a situation like that. So you want to make sure you do it in the right order so that it can be accomplished the way that you want. So involving an accountant, your business's accountant early on, and letting them know, hey, when we sell, this is how we want to do it. So how do we plan for that before, an agreement's in place?
Well, anybody else want to ask a question through our chat box here while we have a couple more minutes before we go into our breakout room session? Okay. Margaret, I'll let you close it out here.
All right. Well, thanks everyone for coming today.